Good evening, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk, the most fact-driven, unbiased, true crime channel. I apologize for my tardiness, but I literally raced back from seeing a client at the jail. So I'm literally just sat down. Anyway, a lot to talk about. For those who have never joined us before, my name is Scott Reisch. I'm a practicing criminal defense attorney here in the great state of Colorado. Have been in private practice here for 20, going on 21 years. And prior to that, I was a judge advocate in the United States Marine Corps. We started this channel a little over 2.5 years ago to talk about the Chris Watts case because I was so frustrated as to what was being said in the press, and nobody seemed to get it right because, frankly, they didn't understand what was taking place. And so that's how this channel started. And here we are now 2.5 years ago, 2.5 years later, and we're going strong. I think we just went over 173,000 subscribers, which, you know, most people think, oh, you just started a YouTube channel and people just flock to it. Those are the stories you hear about. It's a lot of hard work, actually. And I think the other important little statistic that I would like to just mention is the fact that we just also went over 33 million views total. So that was a big number as well. And thank you all. Wouldn't happen without all of you, that's for sure. So anyway, let's get to it. A lot going on. Hopefully y'all saw our show that we put up earlier this afternoon. More motions hearings in the Lori Vallow, Chad-Daybell matter. More motions that were filed. And I'm sorry. I don't get it. Okay. And maybe it's because I'm a criminal defense attorney. You know, I'll probably hold other fellow defense attorneys to a little bit higher standard. I try not to do that. I try to call it as I see it on both sides. And, you know, I'd like to be able to root for the defense, kind of root for the underdog. But, man, I just haven't seen anything that has impressed me and said, wow, that's some really, really good lawyering. The motion that we talked about today in our daily show was the objection to the pro hoc vice. And, you know, Mr. Wood wants to hire basically an experienced prosecutor. She's not admitted in Idaho. So she has a practice in Missouri, and they want to have her admitted pro hoc vice. That's simply a fancy term that basically says, please let me practice law where I'm not where I'm not licensed to practice. All right. I've been admitted pro hoc vice in several states over the years. It is it's a pain in the butt, but I get it. I mean, let's face it. Wouldn't it be nice if your lawyer could go to every jurisdiction? I would think that would be absolutely fabulous. But it doesn't work that way. The bar system is set up as kind of a lot of protectionism, and once you're on board the ship, pull the ladder up. Don't let as many other people on board as possible, right? Because you got to protect yourself. And that's what home states do. They protect their local bar association, so they don't want strangers rolling into town taking money out of the local attorneys' pockets, so to speak. And I get it. I have gone and done cases out of state, and you still got to hire local counsel anyway. So I've told clients, why do you want to hire me? This attorney that we have, local counsel, he or she is very good. Save your money. And like, no, we want you. Okay, you got to hire 2 attorneys. Okay, that's fine. Okay, I'll warn you that, but it's just a pain in the butt. You got to file paperwork. It's not a big deal. We just did it in another jurisdiction, actually on it's a civil case that I'm involved in, but it has some criminal aspects to it. So that's where we are in on that. But it's not hard. You fill out the paperwork. Everybody's like, hey, you're in good standing, no issues, and that's it. So it's It's straightforward. It's straightforward. That's for sure. Anyway, so let's talk about the motions. Let's take a look at the questions first, because this is our Tuesday night show. We do live Tuesday night. We try to answer as many questions as we can for people that have questions. Just put a question in the chat and I will do it. And wow, there's a lot of chats there. Now, we don't ask people, but you can super chat, which will at least highlight the chat, and your chances of getting seen are much better because it kind of jumps out at you. Don't have to do it, but it certainly does draw my attention to it, and we will try to answer as many questions as we can. Now, for those of you who are also new to this, do not forget, immediately following this show, we'll send you the link if you are a Patreon member. So you can sign up for the Patreon right below, and it's nominal. It's less than a cup of coffee, and you have a much smaller forum in which to ask your questions, and you get a bonus because you can call in and you can talk with me. It was really fun. One night we had somebody actually from Idaho that called and said, hey, you should, when you come out, we'll show you around the area here in Rexburg. Fly into this particular airport was your best bet. You know, we asked about where the best place to stay, where's the best place to get a good meal, anything along those lines. And you just never know who's going to call. Everybody usually, our subscribers are just smart people. They're so intelligent. They have such great questions. So inquisitive. I mean, it's a lot of fun. We'll do that tonight. And I think we forgot to do it last week because, well, it wrapped up. But that's right. We ask the Magic 8 Ball. All right. I don't think the Magic 8 Ball has been wrong at all. And the Magic 8 Ball, we try to come up with a question by the end of the show to ask the Magic 8 Ball and see if it comes through. And my recollection is Magic 8 Ball has never been wrong. Now, we jokingly say that we use it to answer all of our life questions, but, it's just done in fun. It's not some sort of weird thing. I mean, people are accused me of being some sort of Satan worshiper for using the Magic 8 Ball. No, it was a gift years and years ago, and it's just always kept it around, and it's just kind of fun to ask the question, see what pops up. That's it, bottom line. So it's just fun. All right. Let's go to the questions. Sheila, hi from South Carolina. South Carolina is my adopted home state. Okay, let's just get this for the record. Have a little house. It's a little rental now, but one of these days, my ultimate plan is to return back to the low country, particularly, Beaufort, Ladies Island, Hilton Head, maybe as far north as Charleston. We'll see. But I love the low country. I love it. I love it. I love it. I want to go back. I can't wait. I love it. Flew out there in November when CrimeTalk won. We had to put some hours on the engine. We flew straight into Hilton Head. Love South Carolina. Want to go. If I could convince the lovely Miss Kristen to hop on a flight, I don't know, Thursday, if I find out what happens tomorrow, if my trial is going to go or not, I think we jump out and go out to South Carolina for a couple of days. Just asking. We'll see. All right, question. Is it possible that Mr. Wood knows he can't put the murder case together on them? Sort of like he's having a hard time coming up with the way of trying all these cases together for the murder. Yeah, I mean, I have been, I don't want to say a critic, but my position has been if the prosecutor thought that they had enough information at this point to bring murder charges against Lori Vallow and Chad Daybell, they would have done it by now. Yes, there is a lot of discovery in a case of this nature. And I don't know the exact number of pages, but I think it's been said it's in the hundreds of thousands of pages. All the downloads that would have come from the GPS data from phones. I mean, that stuff can become enormous. We just had a case the other day. My goodness, I think they said the cell phone dump was like 92,000 pages. 92,000 pages. Somebody's got to read that be able to review it, analyze it, see how this fits in. Are there motions? What investigation needs to be done based upon that? And then you have to be able to try to remember it all so that you know where it fits in the big picture of trial. It's a full-time job, as we talked about, and why Mr. Wood may be bringing on another special prosecutor in this case is simply for the fact that he's the elected DA and he has one deputy district attorney in his office and 2 legal assistants. This case, the Laura Vallow case, could take up their time 7 days a week, 24 hours a day. Hopefully, this lady that was brought in, Miss Stewart, correct, right? Yeah, yes. Miss Stewart. She's going to come in and be able to whip everybody into shape and see if they have enough to bring charges, or let alone just try it. As you can see, it seems like the defense tactic is a death by 1,000 cuts. Let's file a bunch of frivolous motions on a bunch of nonsense, because if the government is responding to those motions, then they don't have to be timed. They don't have time to be working on preparing for the case. So, we've all been there. We've all done that, but I usually like to have at least straight face motions so people don't think I'm wasting their time. So, we'll see. Let's continue on here. Michelle from Washington State. Is it Dougie or Doogie? That was the last question from Ontario, Canada. Thank you. I'm not laughing at Mr. Means' documents. I just don't understand Mr. Means' documents. Some of them have been confusing, okay? Confusing. I've never seen a position such as objecting to a pro hoc vice motion, basically saying, it's too expensive. You can't do it. We can't do it. It's too expensive. I'm not even sure what standing they would have to object to a attorney coming in pro hoc vice unless they had some sort of disciplinary issues in their history. I just, you don't do it. I mean, and why not just go try the case, right? At some point, you're going to have to, you can file as many motions as you want. You can issue as many subpoenas as you want. But at the end of the day, eventually you're going to just have to go and try the case. So focus on trying the case. This is a question of fact. Unless there's something that has been done, and understand we are not privy to all the discovery in the case. I wish we were. But unless there's a lot of search warrant issues to challenge, which frankly I can't imagine, as long as they're specific, as long as they're not general warrants whereby they're just saying, hey, we want to search this phone and we're not sure what we're looking for, but we'll know it when we find it. That's a general warrant. That's prohibited under the United States Constitution. As here in the state of Colorado, our Supreme Court has let many district attorneys' offices know you can't do a general warrant. That's against the law. It's against the United States Constitution, Fourth Amendment. You have to be very specific, right? Why? The Founding Fathers. What did they want to do? Prevent the government from going in and rummaging through your house. The king would show up, his troops would show up, and they'd say, we don't like you today. We think you're speaking ill of the king or the governor that was appointed by the king. And so we're going to go through your house and see what we can do to find and see if you're a criminal. And they go in and, well, what are you looking for? Well, we don't know, but we'll know it when we see it. Hence the reason why our Founding Fathers demanded a warrant that would only issue based upon probable cause presented to a neutral and detached magistrate to review that and decide if probable cause existed so that they could go in and search the items. Well, that still holds true today, ladies and gentlemen. You can't just say we'd like to go look around. And oftentimes that's what district attorneys, detectives do, and judges grant. And finally, people read the stuff So unless that's an issue in all these search warrants, which I doubt it out there in Idaho, like eventually these guys, Means and Pryor, are going to have to go try the case. Frankly, I believe as a defense attorney, their best hope for advancing their client's goal, which is a not guilty, is to go try the case. Quit delaying it. Go try the case. Like, let's set it as quickly as possible. The government's clearly not ready. They've already indicated they're not ready. They need help. They had to go halfway across the country to hire help. That's great for the defense. Prosecution may want to step it up here real quick. And I mentioned this today. It's not bad mouthing Mr. Woods. Hey, at least he has enough courage to say, I can't do it all myself. I need help. It was just very odd that he had to go to Missouri to hire a former prosecutor to get help. You know, it's not uncommon. I've seen district attorneys from other jurisdictions. If there's a case that comes to mind, I was thinking about today was the Kobe Bryant case years and years ago, where they had all the DNA evidence. DNA evidence was still relatively new. So they loaned district attorneys up to go work on that case from other jurisdictions that had much more experience on that. So I just don't understand why he had to do that. But I don't know. I'm not privy to all those reasons. So we'll just leave it at that. Question here by Stacy B on a super chat. What strategy do you think they're using on both sides of Daybell Vallow? How does the strategy play in court case? Well, I think hopefully I tried to answer that was that the defense seems to be file motions, keep them busy. But eventually they're going to have to go try the case. They're going to have to go do their work. We talked about today in our video the whole motion that the defense, specifically Lori Vallow, was asking for all the names of the people that work at the jail in regards to, you know, these motions that have been filed about denying Mr. Means access to his client so that he can conduct, you know, interviews, review discovery, and zealously represent his client in accordance with the Sixth Amendment of the United States Constitution. And the prosecution response was, not my job to do yours. Sounds like you need to go do some investigation. And I agree with the district attorney on that one. If I thought the district attorney was wrong, I would tell him so. The issue relating to who works at the jail, it may be a side collateral issue as to an issue that apparently runs very deep for Mr. Means, and that's to, you know, resolve this issue of why he can't see his client uninterrupted at any time when he chooses to do so. But the sheriff can limit that based upon security reasons, right? Remember how we tried to get a cell phone for Lori Vallow? Hey, wouldn't it be great if I could have a cell phone? Yes, that'd be great. But it's a security risk. It's simply not going to happen. And so that is not the job of the prosecuting attorney to do that. You know, Mr. Means, you know, here we have a super lawyer trick. It's called subpoena. Go issue a subpoena, get a return date, make the sheriff turn over all of the people that were working on that particular day. Who's in charge of this? What is recorded? What hasn't been recorded? Oh, but you may have to pay for it. Okay? And I was also thinking about that. It is so expensive. These people are working on a case literally every day, nearly every day. Let's say they're not doing it. Let's say they're charging a reasonable fee. I'm not sure exactly what the going rate is in Idaho, but let's just say it's $300 an hour. Okay, let's be fair. But let's say they're working 5 hours a day, just to be conservative, times 300. That's $1,500 a day, times, let's say, 25 days, right? 1,500 times 25 days. That's billing roughly $37,500 per month if you go on that standard. That doesn't include expenses. That doesn't include any experts, investigators. So whatever money that the defense attorneys have received in this case, more than likely that's it. It'll be interesting to see if they can hold out and do a multi-week case with all the preparation time that comes with that. Just don't get it. Just don't get it. Why a special prosecutor for Chad and not for Lori? Well, the court somewhat addressed that issue the other day. They filed the motion in the Chad-Daybell case, which kind of made sense because, as you may recall, the court had joined the cases. But then apparently the court thought, well, we better make sure that all our I's are dotted and T's are crossed so there's no issues in the future. So basically they filed the same motion in the Lori Vallow case, and then the objection was filed by Mr. Means, which was basically, and I'm still trying to figure some of this stuff out, waived righted, R-I-G-H-T, maybe waived rights? Waived righted. And, I'm not trying to be total nitpicky, but if I'm catching this because I'm, reviewing it, you would think somebody that filed it and is going to be put in the court for the world to see would try to make it coherent. Basically that he was appointed special prosecutor and they shouldn't be allowed to bring in a pitch hitter. I always thought it was a pinch hitter. But to do it in his job. I mean, I guess apparently the defense just doesn't like the fact that they're bringing in another attorney. I mean, I would be like, that's right. They got to bring in help because we're winning. We'll see. We'll see. I just hope we can get to some real motions hearings and find some real issues here real soon. I think I misspoke today. It was April 4th. I think April 4th is a Sunday. Isn't that Easter or something? But they have a hearing coming up April 6th, April 8th. I don't have it right in front of me. Actually, hold on. Maybe I do have it right in front of me. April 7th is what Frank, the hardest working man in show business, is telling me right now. And if that's the case, let's have some real hearings on some real issues. Let's decide some evidentiary issues because the case is coming up. I mean, this thing is set for trial in July. We're not that far away. And I don't like when judges allow piecemeal motions practice. And that seems to be what's taking place. The judge set some deadlines early on in the case saying you have to file all your motions at this time. And that's not uncommon. The judge gives you deadlines. You enter plea not guilty. You have 35 days in which to file motions. Fine. That includes all motions, including motions in limine. You got to file everything so that the case is getting set for trial. The legal issues are set. That's going to, help people make decisions. But this piecemeal, and I get it, if there's a motion to compel, fine. But make it, and let's say I, as a defense attorney, have filed motions in cases, lost every single one of them, and then won a trial. Okay? So you can't keep score like that. But right now, I just haven't seen anything of any great substance where I'm like, ooh, the defense has really got a great issue here. Just haven't seen it yet. Hopefully, somebody's going to start bringing their A game here, one way or the other. All right, let's go in here. Okay, we got Bethany from Utah. Jen Lowe, so devastated here in Colorado. Can't believe that happened yesterday, Bethany Wood. Looks like Jen, been there tons of times, referring to the King Super. In Colorado now, but beautiful there. Yeah, we talked about today the Boulder incident, and what can you say? I don't know what to say. Nobody has any motive. What we reported on was the brother who said that the shooter is someone suffering from mental disease, possibly some sort of schizophrenia or something along those lines, because he thinks that people are always trying to get him and chasing him and looking at him. Shocking. Somebody that goes and does terrible things to random people that the perpetrator has no contact with in their life. Oh, mental health issues. Wow. I'm so surprised that happened. No, I'm not. And as we talked about in our video today, I mean, it's the elephant in the room. People are starting to talk about mental health issues, but for so long they didn't. And I think I've mentioned this case before, but I was in court one day, and there was a gentleman that was before the court, and he seemed absolutely polite, pleasant to the court, and he had come back for sentencing. And when this individual was up there, his attorney, and I believe it was the public defenders that were representing him, because the man had been released. And it turns out when he was in custody, he was getting his medications. And when he was released on parole, he was given 30 days supply of his medications. And when that 30-day supply of the medications was gone, he didn't have any money to buy the medication. I believe, if I remember correctly, that there was the discussion that these medications cost roughly $200 a month. But now, he had committed a new crime. I think he had assaulted somebody, like at a bus stop that wouldn't get off his bus stop, or something along those lines. But the guy in court seemed absolutely normal. But apparently, he's on his meds. He's schizophrenic and a dangerous one at that. And so the judge had to sentence him to prison. Well, guess how much it was going to cost to sentence him to prison? $28,000 a year to house somebody, and that number probably goes up, obviously the greater security risk that an individual is, but $28,000 a year to house somebody in prison. But if we give him his medications for $200 a month, he's fine and he can function in society. Clearly, and we're not talking about, whether you're where you are in the political spectrum, but think about it. If you're running a business and you can say, I can either pay this expense at $28,000, but if I do this, I'll have to pay $200 a month. That's just a good business decision, right? And there's so many people that have mental health issues, whether diagnosed or undiagnosed, that wind up in the criminal justice system because most of the time they're self-medicating on the drugs that they're taking, which of course usually allows their life to completely spiral out of control until they figure it out and get some help. So 28 versus $200 a month. That's just a good business decision. Let's waste 28,000 or fix them for 200. Let's see. Oh, Shadow Super Chat. Thinking various law schools are ripping through these cases and motions on what not to do. Yeah, it's just bad. And let me tell you a little secret here about motions. All right. You can whip out, boilerplate motions and, judge, suppress the stop, suppress the statements. But to have a real good motion to suppress, it's going to get the judge's attention. You have to put in specific facts of what took place, what the police did that was wrong, and why it, whatever should be suppressed, whether it's statements, evidence, something along those lines. But you have to back it up with some real authority, and that takes time. Good motions practice, and anyone will tell you, okay, I would rather go to court, try a case, than have to write a brief. Not that I can't write a brief, but they take time. And what you really need when you write a good motion or a good brief is complete, uninterrupted silence so that you can focus, you can truly analyze the cases that you're reading. My gosh, we had an appellate brief up to the 10th Circuit. We worked on that thing, and we probably cited 50 cases, and then preparing for the oral argument. You spend so much time, and guess how long the oral argument was? It was 15 minutes long. 15 minutes, and you would literally spend hundreds of hours writing a brief, drafting it, revising it, narrowing it down, refining your argument, and that takes a lot of time to do that. So it's good motions practice takes time. I like to do it when we have the resources. Someone's often said that's what associates are for. You don't rely on them. You have to read it and proof it. But to really dig into it, you need to have somebody delve into it to do great motions practice, that they've dug deep, deep, deep into the discovery, looked at things, chased things down. And like I said, that takes time. And only thing attorneys have is their knowledge and their time. So it costs money. So we'll just have to wait and see what the substantive motions are in this particular case, because right now it's been a little thin on both sides. I'm not gonna lie. Let's see here. I don't want to get too sidetracked. We're not going to get into a gun control debate because they're not going to ban guns, ladies and gentlemen. A lot of people would like to do that, but there is a thing called the Second Amendment, and everyone gets all fired up. One time everything goes crazy. Maybe they should get a little more fired up in helping people with mental health issues. Maybe encouraging people, if you think that somebody has mental health problems, to go talk with somebody voluntarily. Maybe have a little intervention. Hey, a little worried. You seem to be talking to things that aren't here in the room. You're very paranoid, things of that nature about what's going on in life. People need to delve into that. You seem rather depressed. What's going on? Talk to me. My general thinking is obviously anyone that goes and does something like that took place in Boulder yesterday, cowards. I think that's the only word to describe it. Complete coward. What could they possibly think was going to come from this? Now nobody talks about people's names. And I don't have a problem mentioning names because that's a fact. Who did it? Who's accused of doing it? I don't think you're going to discourage somebody else from committing such an act if we don't mention the other guy's name. I just don't believe that for a second. And besides, that's a fact. Could you imagine if we're not going to mention anyone that's ever committed a murder? We're not going to mention Lori Vallow, allegedly, is accused of a murder. Lori Vallow or Chauvin. We're not going to mention their name because maybe that will prevent people from committing crimes similar to this. Really? Does somebody really think, raise your hand if you really think that is going to prevent people. Okay? It's called human nature, people. It's called mental illness. But they're cowards. Yeah. Frida, I'm sorry, but 2 kids are dead and buried. I agree. They are. Are means and prior qualified to do a death penalty case? Trish, no. I don't believe either one of them would meet the ABA guidelines. Understand, they're only guidelines. They're only rules, principles of what you'd like to see. But any attorney could do the case if that was the attorney of choice. But, when people do death penalty cases, it's when you do a death penalty case, particularly if you have the resources, and usually when I mean the resources being funded by the state defense, you're going to have probably 2 trial attorneys, 2 motions/appellate attorneys that are going to be drafting motions. And we are talking hundreds and hundreds of motions that have to be dealt with because they literally challenge the constitutionality of the death penalty laws, the sentencing scheme. They challenge it all. They relitigate everything because you get super due process when it comes to that. And to do a private death penalty case, frankly, bottom line, most people simply do not have the resources to do that. Coral Mansfield, Super Chat. So in Means' objection, he states that he will be calling Woods to testify. Can he even do that? Well, the court has already ruled that that's not going to happen. As you may recall, they wanted to disqualify Mr. Wood. There were hearings on it, all-day hearing on it, and the court said, no, you're not going to be able to do that. Hell, there was an audio recording. You'd call the person that did the audio recording. That's it. Bottom line, to authenticate what was said. But there's nothing in there that would indicate to me, which I said when I heard the recording, and I know we have it up somewhere in one of our videos, but there was nothing that was offensive to me whatsoever. That was a very candid, straightforward conversation that he could have with, here in that particular case, a family member of the deceased, of Tylee and JJ, asking what's going on. And he acknowledged, well, I understand, you're, the sister here, and, you're in a tough spot. You obviously want justice for Tylee and JJ, but it's your sister. I get that. And he's just pissed, I guess. Means is just upset that Woods called him out, saying basically, when he's not calling me a liar and accusing me of doing wrong things, he doesn't even do criminal defense. What is inappropriate about that? I don't know why he just can't seem to get over that. I don't understand why Mr. Means can't just get over the fact that sometimes you got to go spend your evenings and weekends at the jail on big cases, even on little cases. You have to make sure the client knows what the hell is going on in their case, understanding what's taking place, and you got to go do it. You got to go sit down at the jail and go through it, no matter how uncomfortable, inconvenient it may be. You have to just go do it. Let's see here. Let's see here. I'm trying to see some of these questions. I can't believe we're already 40 minutes into it. Wow. All right. And can you believe it? 40 minutes. Goes by so fast. Let's see if we have some questions here. A lot of people talking back and forth amongst themselves, which is great. Bethany Wood, welcome. You have dogs. What breeds? True helper. Oh, that's, yeah. We had the lovely Miss Winnie. Miss Winnie the Bulldog. You can follow Miss Winnie on Instagram and TikTok. Cutest dog ever. Smartest dog in the world, I must say. Clearly, the smartest dog in the world. And just so we're clear, she was not named based on Winnie the Pooh. She was named on Winston Churchill. But we couldn't call her Winston because she's a girl, so we had to call her Winnie. Christine Robinson, Lori Vallow-Daybell is the gift that keeps on giving, except for those in her life. I'll be honest with you. I get up every day and I think to myself, I wonder what they're going to do in the Lori Vallow, Chad Daybell cases today. You just never know. It kind of goes cold for a little while, and then they file something, and it's just a couple of days of great talk and conversation. So to Mr. Wood, Mr. Means, and Mr. Pryor, thank you. And to Lori and Chad, obviously we'll give you the presumption of innocence. But if you're convicted, let me know. Thank you. I just, seriously, you can't do it. You can't do it. All right. So we talked about Lori Vallow then. Yeah. We also talked about obviously going on in Boulder. It's a tragedy, but the person that does that, I don't care who does it. Coward. Who goes in and harms somebody to kill them like that? It's not even a fair fight. Really? It's just cowardness on my part. Like, why don't they ever go to the police station if they're going to think they're going to do something like that, right? Why? Because they know people are going to shoot back. That's what makes them cowards. Why don't they go to a gun store where everyone working in the gun store has a firearm strapped to their hip? Why? Because they know their people are going to shoot back. It just pisses me off that they always pick these soft targets because they know there aren't going to be any guns there. You know what? Maybe King Soopers maybe has an armed security guard. Maybe not. I know the one near my house, they've got a police officer that stands there at the door, but apparently not in Boulder, because nothing happens in Boulder. And, we mentioned this today a little bit. I mean, Boulder is a beautiful place. It's got a great school. The surrounding mountains, everything are absolutely beautiful. But it's a different place. It's a different place. And of course, everybody's all upset at a judge up there that struck down an ordinance that would have banned assault rifles in Boulder. And the judge said, we have no authority as a municipality to do that. It's got to be the state to do that. And nothing exists. So, you can't do that. And of course, everyone, see if they would just ban the guns. Well, the man lived in a different city, and as far as we know, drove to Boulder. And I don't think, because it's against the law to kill people, last time I checked, I don't think that's changed in any way. Apparently, that law was not a deterrent. So I can't imagine possession of a rifle that he took into the store would have deterred him. Do you think this man, who, as we may know, or we'll find out more as time goes by, whether he had mental health issues, do you thinking, hey, I want to go take out as many people as I can, completely innocent victims who have done nothing to me, but I just can't do it because there's that ordinance in Boulder that was passed. I just can't do it. Like, come on, people. I mean, and we've tried to bring it to you straightforward on every case that we possibly can. We just tell you the truth, right? I'm not running for any political office. I'm not asking anyone to buy large item things. At most, it's like, hey, you want to buy some merchandise? If you don't, great. You want to join Patreon so we can have a more private, intimate conversation? Join Patreon. But if you don't, that's fine too. So all we can do is look at the facts and the law, and call it the way we see it. And for someone who's 26 years now, starting my 26th year of practicing, primarily criminal defense, that gets to see people usually at their worst moments in their life, when they've been accused of doing something, you get to see a lot and look into the eyes of people and look at human nature. Does anyone think that anything that we're dealing with here today has not been dealt with throughout history? Do you think we didn't have mentally ill people? They used to just lock them up into an asylum. Now we can't do that. Remember back in the 80s, they said you can't do that. You can't keep people there. Sure, they're a danger to themselves and to others, but we can't do that anymore. And I'm not saying if that's right or wrong. I'm just saying that's what it is. We don't have those types of asylum/institutions. But like I said, I'm just going to tell you the way it is. If I give my opinion, my advice, that's what I think it is based upon the facts of the case. As I've said this before, when I give advice to my clients, and if I give my opinion, my advice here, whether somebody calls in like on our Patreon show, I'm going to give you what I think is correct. Like I was giving advice to my own kids. And not that I treat you all as my children, but you know what I'm saying. I would give you sincere advice because that's what I truly believe would be the right thing to do. I wouldn't, give bad advice. Certainly wouldn't give bad advice to a client. Wouldn't give bad advice to anyone here. Certainly don't want to make a bunch of just over the top analysis and predictions. I mean, I may still I practice law. This is not my job. And whether we get we're at 33 million views, I think, total. Okay, if it stopped at 33 million and one, and it means that I didn't have to just say bombastic, ridiculous stuff to get views, which has never been our goal here. Our goal has been the truth. To give you the facts, like the name of the shooter today. We gave the facts. Some people, well, if you don't give his name, maybe it'll prevent it. Really? what world is someone living in to think that somebody can't go Google the guy's name or anyone's case that's been involved in the media? You can find it, but we're not going to say it. I mean, I don't know. I think there are certain people out there that just think that the citizenry are just stupid. I think that they think that we're all just too stupid. We're too stupid to know the facts. We're too stupid to make our own decision. And by God, just do what we're told. And it's just amazing to me. When I went to school, it taught you how to think, not what to think. And that's the problem. Too many people just want to be told what to think, not how to think. You know, I love it when somebody sends me a comment and says, hey, Scott, you know, I never really used to like defense attorneys. And hey, guess what? There's a lot of defense attorneys I don't like. There's a lot of attorneys I don't like. But I like it when somebody says to me, hey, Scott, I listened to you. And although I'm, you know, obviously still very one-sided on a particular issue or a particular case, I respect what you're saying because it taught me to look at the whole picture. You don't have to agree with me. I mean, nowhere have I ever said, agree with me or leave. Hey, frankly, if you disagree with me, highlight it. Hey, Scott, I disagree with you. Tell me why, convince me why I'm wrong. On Patreon, you disagree with me? You can go first. We'll call, you go first. You tell me why I'm wrong. Convince me if I'm wrong. Maybe I'll change my mind. Okay. But this stuff is not going to go away. This is the stuff that's been dealt with for thousands and thousands of years. And we act like it's something new all the time. And it's not. It's not. We just try to repackage it every few decades and try to make it all sound new and inviting, but it's not. And there's the pendulum. You know, back in the 80s, you had the tough on crime. Now you've got the swing of, if we just gave everybody a big hug, wouldn't everything be okay? No. Okay? Because let me tell you about human nature. There's always going to be someone that's going to take advantage of the weak. There's always going to be someone that's going to take advantage or take something from someone because they think they can. Whether they can take it by trickery or by force, they're going to do it. And there are some people, and I think I've said this before. I've only met true evil a couple of times in my life. Normally, as a defense attorney, you can find something good to say about anyone when it comes to a sentencing hearing or have a conversation with a district attorney about somebody. But I've met true evil where you're like, oh yeah, prison for the rest of their life is exactly where they belong. Okay. But there are people out there like that. And this is from a defense attorney who tries to find the good in everybody, who tries to defend the Constitution, right? Give them a fair trial. They got to go to prison. That's okay. That's fine. That's the way the system works. But you can't railroad them. You can't. You got to give everybody due process. All right. Paula, do you think Lori is using means so that when she gets convicted, she can claim incompetent counsel or may fire him before trial to keep up the circus? You know, Paula, at this point, I have no idea. Every day is a circus when it comes to the Lori Vallow, Chad Daybell matter. I like the judge in the Vallow-Daybell matter. I just wish he was a little more firm and simply say, hey, you got your motions filed. We'll take them up as needed, but none of this piecemeal stuff. I mean, it's good for us. We'll take the content, right? We'll have emotions every day. But, I just kind of see a situation where if somebody doesn't put their foot down here real soon, we're going to have a Judge Ito type situation like in the OJ case where what should have been at most a 2 to 3 week homicide trial is going to turn into, 11-month adventure or something. Come on. Most cases are not that complicated. Most cases do not have any novel or unique evidentiary issues. So file your motions, set a deadline, and have the hearing. Will she fire him? I don't know. What I do not like is the fact that neither Lori Vallow nor Chad Daybell show up to any of these hearings. I do not like that at all. These are motions hearings in their case that are affecting issues in their case. They should be present. The judge should require their presence at every proceeding. And in today with Zoom, or WebEx, there is no issue why they cannot connect them from the jail so that they can be with their client and their clients can see what is going on and say, what the hell are you talking about? That doesn't make any sense to me. Explain that to me. And I'm not saying there would be ineffective issues. First, that assumes that they're going to get convicted, and we're not going to do that. But the issue, where do attorneys get in trouble, right? 3 general rules they teach you. Don't steal your client's money. Don't sleep with your clients. And third, communicate with your clients, right? Piece of paper comes in, new motion, client gets a copy. Your response, client gets a copy. They come to court at every court date to see what's going on. You send them a letter saying, as you know, we appeared in court today. This is what took place. They said this. They extended offer. Deadline is this. Boom. From the outside observer, yes, I get it. Some people say, oh, this is just administrative matters about whether we're going to allow in the special prosecutor. Well, guess what? If I'm the defendant, I think I may want to look in the eyes of the prosecutor that's trying to send me to prison, even if it is only for 10 years for the alleged death of 2 children. Right? That's the thing that worries me. If I was the judge, I would make them appear, and I would have the proceedings held in the courtroom. It seems like Means is bothered by the add-on. It's not possible. I mean, he's probably thinking, I got a case to try here. And yet we're dealing with all this nonsense, but yet he keeps starting the nonsense and some of this stuff. So I just don't get it. Like, let's go try the case. Linda, are the Daybells in general population? I have no reason not to believe that they are. I don't have any specific information. But, we're not talking like they're at some inner city jail with, gang population. I mean, I'm sure most of the people in custody there, usually not going to be, violent crimes, usually, drugs, alcohol, not dangerous stuff. Shauna, I've heard this before. Lori can't get her hair colored, and so she doesn't want to be on video. At a certain point, she needs to get serious about this case. Maybe she's not, but I don't know what to tell her. But if I tell clients, hey, we're gonna waive, you don't have to be here. We're gonna do jury instructions or something. I got clients most of the time that say, oh no, I want to see what's going on. I don't trust anybody here in this situation. I want to be here. So it surprises me that they're not there just to know that what's going on in their proceedings and not taking the word from their attorney. C.L. Lewis. Is it legal for my ex's divorce attorney, who's now a district attorney, to file charges against me? Is that not a conflict of interest? I generally say yes, it is. I actually just had that issue on a case, small town. The prosecutor is now, the elected prosecutor, used to be my client's attorney, raised the issue, and the judge poo-pooed it like, Mr. Reich, it was so long ago. Why would you raise this issue? I just don't get it. Because he represented my client previously. He has confidences that he could use against my client. I'm going to raise the issue. So yes, I would say that. Okay, Shadow, questions about Chris Watts? Sure, why not? Let's go through here and see if we can see everything else. Scott, your passion for the law and your clients is evident. Was there any time you were held in contempt or almost held in contempt for your passion for defense? Yes. One of my associates, we were doing a trial the other week, and I mean, this was all broadcast live, and had an expert witness who was testifying about expert witness stuff. And the prosecution jumps up and it's like, we object. This is not in his report. We only are aware of 7 photographs in his report. I'm like, but they're all referenced on the disc that's referenced in the report that was turned over 7 months ago. And I swear to God, the DA jumps up and says, we didn't open it. We just relied on the report. And I said, Your Honor, I'm standing here like, are you kidding me? His laziness, his lack of diligence for 7 months not to open the supporting documents for a report. If I had done that, or failed to do that, I guess is a better term, I would be calling my malpractice carrier. My associate, who can be a little aggressive, was like, whoa, calm down. Like, I think you're going to, because I was holding my arms out. Like, are you kidding me, Judge? What are you going to do? Like, are you kidding me? Yes. Come close. I had to show cause once, but that was because I was supposed to start a trial and I was doing a guilty plea upstairs and they sent the sheriff up to get me. And I came back down and said, show cause shall issue. Bring in the jury. I'm like, oh, geez, getting the day started off well. That was the case. I'll never forget it because my client was charged with a DV case and my entire jury panel was 6 women. It was a misdemeanor county court case, 6 women. And my client goes, what do you think? And I'm like, oh my God, I hope you brought a toothbrush. You're going to jail. Oh my God. I'm like, this is just going terrible. Ultimately, we got a not guilty on the case. And that was where I realized at that particular moment, in that particular case, if your key witness is a female, you want female jurors. Right? People are looking at me. They're like, what? Why? Because females are more harsh and judgmental on other females. They will tear them apart. You don't have to even ask a lot of the questions. The jurors are asking it or thinking it. And, ever since that day, it was something I learned. I'm like, wow, those jurors do not like that victim. They think that she's at fault. Oh my. And that theory has come true many, many times. Just don't know why. But, women can be very mean to other women. Very, very mean. So we'll leave it at that. Wow. Can you look at that? It's already an hour. Thank you. Wow. I can't believe it goes by so fast. All right. So we're going to take a quick break. We're going to go to our Patreon. If you haven't done so already, please sign up. Frank will send out the link here momentarily, and we'll start up again. You can call in. We'll give you the secret phone number to call into when you are here for the Patreon. And then we'll take questions, and we will never forget the Magic 8-Ball tonight. So thanks for watching. Have a wonderful day, and we'll see you in a moment on Patreon, and we'll see you tomorrow on Crime Talk.